Yes.
Of course, we're starting from the appointment
Yes,
committee,
of course.
right?
So one of the things yesterday at the point in time, I felt like I was in court, watching cross-examination
I
between
tell you.
Afenyo and
Sam
Sam George, and it was quite very interesting the way he was responding to the question, the kind of questions that he was confronted with. And one of the issues has to do with the anti-gay bill that went to court, the cases.
You know
And then
that,
it was very...
you know, Mutala, I mean, as a student of law, right, you would appreciate the kind of questions that
Absolutely.
Afenyo Kings was asking. And I think that politics, emotions aside, some of the questions were very intelligent questions.
Absolutely.
We cannot be a people that hates corruption so much. Say that our politicians are corrupt and still be the same people who have a problem with a nominee being asked how he's funding his lifestyle
Absolutely.
and his education. That is certainly hypocrisy, because if the questions are not asked, we sit here and we say, how do MPs, you know, how are they able to afford even taking care of their constituents? Because
Absolutely.
we all know how much they earn. But an MP who is a nominee says that he goes to London every month, certainly flying on business class. That is nothing short of $5,000 every month.
Source of funding.
You know, and we get angry that some of these questions are being asked. We need to be very honest with ourselves.
No, for me,
emotions aside,
absolutely,
these are conversations that we actually need to have.
It's not for the personnel or those in Parliament, for the consumption of the public. And like I mentioned, it felt like I was sitting in court watching cross-examination between Sam George and Alexander Afenyo in relation to that. Like you mentioned, some of the questions, immediately you won't understand. There were many times that he said that, look, I'm laying foundation, and then the chair will say that I overruled you, or that particular question I'm not going to allow. It happens also in court where a judge feels like, look, this question is not fair for the witness to answer. Move on to the next one and all of that. But of course, some were asking very intelligent questions, and so there were some who will come and you ask yourself, wow, these people are representing their constituents, and then their constituents have asked them to come to Parliament and say goodbye to a nominee and say, go have a sing praises of nominees. Some of the things, Charlie, far below the bed. But of course, like we were mentioning, Sam George was in Parliament yesterday, appointment committee, vetting and all of that. And we saw what happened. The issue he had with regards to the anti-gay bills, cases at the Supreme Court, all of them came to the fore where he was, in fact, it was grilled, like I mentioned, cross-examination before the bar. But of course, he's also been responding. And one issue, the issue he had with the Chief Justice, how the Chief Justice handled the issue at the Supreme Court. And at one point in time, the way he was making the point, he was struggling at the point in time where the issue about the judgment, saying that the Chief Justice was on the panel of the substantive matter, when indeed it wasn't. The CJ was on the part of the panel, the 5-member panel that heard the interlocutory matters, the interlocutory injunction, aside the substantive matter. And that was where the CJ chaired. When it came to the substantive matter, it was Justice Lovelace Johnson that chaired that 7-member panel that had both substantive cases involving Richard Sky and then Dr. Amanda Odo. But what is curious is that we were told by the CJ's panel that their decision in relation to the interlocutory injunction will be factored into the final determination of the case. But if you read the whole judgment, we didn't hear anything on that. But let's hear from Sam George and how he thinks about that criticism he's had over the Chief Justice.
My words were that she had the power to move the case faster than it was being done. And subsequent actions after the demonstration that I led have actually proved my position to be true. That when the Chief Justice gives a timeline, everybody, respondent or plaintiff, Attorney General inclusive, must abide by it. When she invoked her powers, everybody complied. So my contention that she could have expedited it if she had given earlier timelines were proving right by her subsequent actions. My words were that she had the power.
So that is Sam George responding or reacting to his position about what he has said about the Chief Justice.
Did you think that he was also being too, what's the word I'm looking for? The criticism was too much? Did you feel that he attacked her?
Yeah, for me, I thought that, yes, the tone, the words could have been managed some way, somehow better.
In terms of his responses at the vetting or the tweets that was referred to?
Both the tweet and his responses.
Yeah.
Because if you follow things that happen at the court,
yeah,
and then you are outside and you are not too sure what happened in court, definitely you made certain statement that later on you get to know that no, if you knew earlier, probably that wouldn't have been your position. But from an informed position, and for those of us who go to court, say things, come out and listen to what happened outside, sometimes the gap is too wide. But of course, that is his position. He has been so much involved in this particular anti-gay bill cases and all of that. But I think that some of the words were too strong for the Chief Judge. But Sarah, one thing is also happening, the Constitutional Review Committee.
They were sworn in yesterday.
Yeah, they were sworn in yesterday by the president at the Jubilee House. And guess what? The Attorney General, Dr. Dominic Ayine, was there, and he has a message for this particular committee.
The president and I have invested a lot of hope in your capabilities, experience, and your commitment to the service of our nation. Mr. President was very specific that he wanted a committee consisting of our compatriots who not only represented our country, but who will inspire confidence in our people. He was also clear in his mind that he did not want a partisan committee. So, you have been carefully selected to do this job for our country. The easiest part of the job is to follow the specified methods of alteration of the Constitution. The toughest, and I can say this without any fear of contradiction, is to recommend substantive provisions to add to or replace the current provisions of the Constitution that will conform with the welfare principle of Article 1, Clause 1 of the Constitution, which provides as follows, quote, "The sovereignty of Ghana resides in the people of Ghana, in whose name and emphasis and for whose welfare the powers of government are to be exercised in the manner and within the limits laid down in this Constitution."
So that is Dr. Dominic Ayine, the Attorney General of the Republic of Ghana, the principal legal advisor of the state, giving some urging the committee members to put Ghana first in all that they do. And so why yesterday at the Court of Appeal there was an action in relation to ANAS number 12 expose, Kwesi Nyantakyi in mind, and of course Ghana football as a whole. That documentary was aired, led to Nyantakyi being banned from football, and in fact he was arraigned. He's been charged together with Abdullahi Al-Hassan, a former representative of Ghana Football Association at the northern part of the country. And the case, the trial, I must say, is yet to start. Why? Because the prosecution is still struggling to get their witnesses in court to testify. And their key witness here is essay investigative journalist Anas Arimiyao Anas. The court said that they, in fact, moved a motion at one of the time, sometime in 2023, asking the court that they want Anas to testify in camera, that is in chambers, not in open court. But the court in ruling, making the ruling on that, said that, look, Anas will come, unveil his mask for Nyantakyi to see his face in chambers, but will come in open court and testify with the mask. Both parties were not happy with the decision. The AG is not happy that the court is saying that Anas should unmask in chambers. And Nyantakyi is also not happy that the court is saying that Anas should come and testify in open court with a mask. So both of them went to the Court of Appeal. It was the prosecution that went there, took their application there, but both of them went and argued their cases. Yesterday, a 3-member panel of the Court of Appeal, presided over by Justice Anthony Opon, with Justice Kwekute Teria Akabuafo and Justice Abuaji Stando as other members, dealt with the matter. And guess what their decision is? Anas Arimiyao Anas, they have in fact quashed the decision of the High Court and said that Anas Arimiyao Anas, if he's coming to testify in the case of Nyantakyi, should remove the mask. Come to open court like you can see my face, like I can see your face. Talk to everybody, because the person you are accusing has to see who is accusing him. As simple as that. The court is saying that You are a lawyer, you have stated that in your document, and you say you are an investigative journalist. It means that you have classmates and peers who knows your identity. So why are you saying that you want to come and testify in mass? So Court of Appeal is saying that Anas should come to court. If he intends to testify, then he has to testify in mass. Then the last one, State OBS.
I wonder what will be the next course of action for both of them. You know, because I certainly, I'm so sure that Anas won't budge.
No, that one for sure. It's
Yes.
certainty. Because earlier, when the High Court gave that order that he was marked in chambers, he came out with a statement and said that for his security reason, he's not going to come.
Right.
That is one of the reasons why prosecution had to challenge this particular. And the order that has been made, I can assure you that Anas will not come to court. And if he doesn't come, what is the status of the case? The court has already threatened that the accused persons would be discharged, but they were waiting for the outcome of the Court of Appeal. Now the Court of Appeal has spoken, unless they decide that they are going to the Supreme Court to challenge that.
I expect that to happen.
So if they do, but remember, before coming to the High Court to come and ask, the court has already ruled that now should testify with a mask on and orally. That was an oral application. And then they went to the Supreme Court, and the Supreme Court said that Anas should testify with a mask off. So going back to the Supreme Court, it's like it will be time wasting. So what I know for certainty is that Anas probably will not come to court in relation to this one. And Nyantechi and Co would be discharged. But on the 13th of February, the High Court will sit. Senate OBS, yesterday, former Director General Ernest Thompson and 3 others were in court. And he notes that on the 3rd of December, Justice Henry Anthony Kofi made an order in relation to submission of no case, acquitted Asana Kramer, and then the remaining 4 are asked to open their defense. In fact, one of the accused persons, there was some of the counts that he was acquitted and discharged, but omission, there was an issue of omission, and he was still asked to open his defense. Yesterday, that was clarified. But Justice Henry Anthony Kofi has provided timelines for the accused persons to file their witness statement. And on the 13th of March, this case will be back in court.
Thank you very much.
So we are adjourned sitting today.
Thank you so much.